For hearing, item number 1.
Attention. If you receive calls from unknown.
Yes, my lord, I can hear you. My lord, am I audible? I can, my lord, am I audible now? Hello?
May I seek your lordship indulgence? My lord, this is one case which we filed yesterday. It is an IA for. Can it be listed tomorrow?
For?
Can it be listed tomorrow?
IA for?
IA for additional documents.
Okay.
Yes. Obliged.
Let it be for any other court. Okay. IA for additional documents.
IA for additional documents, and in my lord, we have some. The main IA is for condemnation, which has returned. Edicat has returned.
For which AD card has
Yes,
been
my lord.
returned.
For
Okay. How many
condemnation.
days?
Condemnation of 535 days.
Oh. You can file some. No problem.
Obliged.
It's a DB matter, single bench.
Single matter, madam.
Before the concern bench.
Daily list for motion item 1.
May it please your lordship. It seems there have been some formal defect in my petition, my lord. So if, with your lordship's kindness, if I may be allowed to withdraw the petition with liberty to file afresh.
I think so. Okay, right. Right, Miss
Valentina Aldinpuy.
learned counsel for the petitioner, pray that she may be allowed to withdraw the writ petition with petitioners, with liberty to file afresh. Who is appearing? Miss Zaidam Sampui, CGC, appears for the respondent number 1. And for the state, you and Mr. Yeah, Mr. Samuel Warnfeld Chankle is there. Well, Mr. Samuel Warnfeld Chankle appears for respondents number 6 and 7.
And accepted the copy of the petition.
Anyway, how does it matter? The prayer of the petitioner's counsel is allowed. The writ petition is dismissed as withdrawn. Come on, with liberty as paid for.
Obliged.
For admission item 2.
May I please your lordship? My lord, this is a criminal petition invoking section 482 of the CRPC, inherent powers of the court. And in the new
Why is
act,
CRPC?
in the new act,
Now it's
sorry,
in,
my lord,
huh?
my lord, it's 528 BNSS. And my lord, we had invoked section
So
483.
when did you go to jail? When were you arrested?
31/7/2024 at 12:15 p.m.
31/7.
Yes, my lord.
24. Wait. Kada kana in one order kada item. Lalram parity kada. Kada kana kada kalsira kan. Andro lalu no. Or have I put it in the other file again? So your case is same as that Lalram Pari's case.
The Rampari is same co-accused. She is also another co-accused in the case.
You were arrested when? 8/8. And you were arrested on
31/7.
3rd/7. So it's on the same issue basically.
Same issue. Apparently, my lord, the main SA was recovered from 2 person on 23/7/2024 from Iman Hossain, Ripan Hossain, and another one Niranjan Karmakar.
From a pickup in Dulte.
Yes, ma'am.
Yes. Yes. So basically, so what is your case? They are asking for what? What are you praying for in this petition?
To quash the extension order, which is passed by the learned trial judge.
So what's the extension order? Same order challenging.
Yes, order dated 14/1/2025.
Okay, same order has been challenged. So, extension order, and when were those other 3 arrested? Have they been arrested, those other persons from whom the heroin was seized?
Yes, my lord, they were arrested on 23/7/2024.
Okay, so it will apply to them also. Then this order passed to.
Yes, my lord. To all the other cases, if they filed a default bail application.
Linking lets you use the same WhatsApp account on more than one device. To do this, open WhatsApp on your primary phone and follow the instructions below.
Okay. So when did you file a default bail application?
My lord, I.
You have not filed.
I have not filed, but here before the Honorable High Court, this bench, we have invoked section 187, which used to be section 167 in the CRPC. Because before
You have invoked 187.
I have invoked 187.
When?
This application was filed on, my lord, a month, way before the charge sheet was filed.
No, it's okay.
My lord, the exact date is,
So what has happened to your 187 application?
my lord, it's here because when
No.
when 180 days lapse,
Madam, please understand. Did you file it here or before the trial court?
before the trial court, before 180 days lapse, this order was passed. Extension was already
Agreed. Have you filed a bail application after that? No.
there. As far as my knowledge is concerned, no.
Then there is the question of bail. You are only just
Because, my lord, I did not have a locus standi to file the default bail because extension was already passed by the learned trial judge, and that is why and only after that we realized that there was an extension order, and that is why we approached this Honorable High Court.
okay.
My lord.
Let me finish off this case because your case is going to be dependent upon his case. Okay. Then you say, this item, we are going to take up item 3 and 4. Give me 3 and 4. So, you just say, heard Mr. S. Vanlal Shriyata, learned counsel for the petitioner, in criminal petition number 9 of 2025 and in the bail application number 15 of 2025 involving the same petitioner. Also heard Mr. C. Zoram Chana, learned special public prosecutor for the Narcotics Control Bureau, bracket NCB, in both the petitions. Then, you see the second para will be this second para, make it A, 2A. No, wait, in criminal petition number 9 of 2025, in criminal application, in bail application number 15 of 2025, the petitioner has paid for grant of default bail in terms of section what? Section
483 read with 187 of BNSS.
No. In terms of section 187, 3 and 4. 187 bracket 3 and bracket 4 of the BNSS, which is similar to the repealed section 167 bracket 2 CRPC. Correct?
My lord.
Okay. Then we take up all this, We take this, then 3, 4, everything is correct. Okay. then everything goes. Then para 25. I've got the records also with me, Mrs. Oram Chana. I have seen the records.
My lord.
They were not produced that day, and no
Seems, yes.
lawyer was there.
My lord.
In view of the reasons stated above, the petitioner is to be released on default bail in terms of section 187 bracket 3 bracket 4, correct,
My lord.
of the BNSS on a bail bond of rupees, how much? It's quite huge amount, 2 lakhs. On a bail bond of rupees 2 lakhs.
My lord, regarding that bail order, now in this criminal petition, what have they prayed for and challenges for quashing?
I have quashed.
Of course.
I'm joining the thing, the bail and bail application and this
My lord,
also.
my lord.
Because it naturally follows. Once that thing goes, the order goes,
My lord.
then default on a bail bond of rupees 2 lakhs with one surety of like amount to the satisfaction of the trial court. No, to the satisfaction of the special court, NDPS
NDPS.
Act, ISOL. The bail is further subject to the condition that the petitioner shall not leave the jurisdiction of the special court. Shall not leave the jurisdiction of the special court NDPS ISOL. And shall submit what? Shall submit what? Some documents is required? No. And shall submit.
Now, yes,
A
there.
copy of Aadhaar card. Have you got Aadhaar card?
Yes, my lord. We have Epic card also, my lord.
Actually, what we'd like to know, one them is on their assurance of attending court.
No, that we will write. Then we will also tell them that they shall approach the IO as and when called for.
My lord, my lord.
All that will be there. They shall, by depositing their Aadhaar copy of the Aadhaar card and voter ID. So stop. Next para, number 2 me. 1, following conditions, 1, then 2. 3 in each. Next 3 will be the petitioner shall attend the court as and when required to attend the court. Number 4, the petitioner shall also.
Actually, if I'm not mistaken, the charge sheet also has also been now filed. my lord.
Has been filed?
Yes, my lord. On 15/4.
On 15/4.
Yes, my lord.
And that changes everything.
No, my lord. So I have filed this default bail application on 11/4 before this court.
No, my
Okay,
lord.
on 11.
Okay.
Okay, he's.
It's on 11, my lord.
Huh?
11.
Yes,
It's
before
on
the
11.
charge sheet was filed, my lord. I have
Charge sheet
already
was filed when?
11, my lord.
No, 15. 15, my lord.
I
It's
have a
already.
photocopy, my lord.
No, it's
Give me
already
the
here.
records. Give me the records.
And then my default bail was rejected on 21/3 by the learned trial court, my lord.
It's on 11 April, lord.
Three 4/25 charge sheet is awaited. Accused are remanded back to judicial custody for further investigation. Seen and received charge sheet 11. 11/4.
I may have mistaken. But my lord.
There is the records. Seen and received charge sheet from case IO. So. Charge sheet. And your petition.
Actually, the charge sheet was filed in the forenoon, my lord.
But my lord, the trial court rejected my default bail application on 21/3, my lord. 21/3. Before the charge sheet was filed.
The problem is now charge sheet has been filed. I don't know what to do.
Actually, the
Well,
case
it's-
IO himself also appeared before the High Court at the time when the other petition was to be taken up for showing that charge sheet which he was about to file. But on that day when that was 9th of April, I saw him myself, my lord. He appeared before the High Court also. And the learned special judge, my lord, on that 9th and 10th was on leave, my lord. So he was waiting for that. And on the very next day when she joined.
Look, one thing is sure. I am going to set aside the
My lord,
order.
that I have no say.
That has to go.
My lord.
But whether
I agree.
bail can be given,
My lord, exactly, that is why.
that is now another issue.
Exactly is.
You have to give me, because in the meantime, now charge sheet has been filed. I didn't know charge sheet had been filed. If your petition was before the charge sheet, I would have given you bail.
Exactly.
But the petition, the thing has been given on the date that, okay, you see, don't change anything. Don't change anything of this order. Just remain same. Huh? It will remain the same. This, that A you cut, huh? Everything. This will remain the same. No change. Then today's date is 25, no? 24.
24.
24.
My lord.
Okay, I will complete this 9 first.
My lord.
I'll have to change this slightly. The impute order passed by special court is hereby set aside. Okay. I'm setting aside that order. Wait, then I'll have to change slightly. You said that with regard to bail, you said you yourself, Mr. Zoram Thana, yesterday you said that you should be given the liberty to rearrest the petitioner if charge sheet, at the time when charge sheet was filed. That's why I granted bail. I was going to grant bail.
My lord,
But now it has to be changed.
Yes, since the lordship was of that view that yes, that liberty anyway, now even after filing, my lord, that's open for them to rearrest. If I may, lordship, in the meantime, my lord, call for the Jigar case from SCC version, my lord. Citation. I think this one is not similar, exactly similar.
It is similar. It is similar.
But the
Because
paragraph-
it's only because you see the thing is that in NDPS it is 180 days and extension can be given for 1 year, another 1 year. In that 2015 case, Gujarat case, it is 90 days or 180 days. 180 days instead of 90 days. It be 180 days which can be extended by 90 days only. So, the dates, the extension period, and the time for completing an investigation is different. But the ratio of the case is the same.
Actually, my lord, now in the SEC version of this Jigar case, there is one paragraph which I failed to find here in this life law version, my lord.
Acha.
There is a paragraph that says that they have to, okay, now regarding that, I agree, my lord. But regarding whether they are entitled to get bail, they have to apply after default bail is entitled, but before charge sheet. That is specifically therein. But now here in this version of life law, my lord, I failed to find it. So if that may
But
kindly-
before charge sheet. But before charge sheet.
charge sheet.
No, but he applied. He applied.
Yes.
In his case, he applied.
Yes.
He
But-
applied.
but-
So he's entitled to default bail also. He's entitled to default bail. He's entitled to
But
default
not
bail.
in this petition, I think.
No, he's entitled not in this bail. No.
Not in this bail petition
No,
is after
no.
filing of charge sheet, man.
No. But then it is this this challenge has been made in pursuance to the rejection of his
My lord.
default bail application.
agree, my lord.
So he had made a default bail application. That default bail application was submitted when?
Before this court, my lord. No, trial court on 21-3.
21.
That I agree, my lord. I agree.
So that is after 180 days it expired.
My lord.
So he is
But before
entitled to
charge
bail.
sheet, yes. But now, this present bail petition, my lord.
No, 21-3 was the rejection order.
Rejection
When did you submit?
Yes, on 21, on the day itself, it was
He re-
marked, my lord.
On the day itself it was
Yes,
served
my
and
lord.
rejected.
Yes.
Okay. Okay, we'll grant him bail. We will grant him bail and everything. So you see, at the end, A had to same, it will remain. That para 1 and para 2 had to come on. It will remain. Okay. Then para 9, he got that. The learned PP submit, the learned special PP submits that charge sheet has been filed on 11/4/2025 against the petitioner and the other co-accused. And as such, he's on my wrong. Okay. He's on my wrong. Para 9 no? The next, come to the thing. Come to this. So I will not change anything. Para 23, okay. Okay. Para 24, okay. Then para 25. In view of the reasons stated above, the petitioner is to be released on default bail under dictation. Section 187, 187, 3 and 4 of the BNSS and bail bond. The bail is subject further subject. With the special court. Number 2. As and when directed to attend the court. As and when directed to attend the court. Number 3. Shall also appear before the case IO as and when directed to appear before the case IO. Next para. The petitioner shall not take any steps to intimidate the witnesses, full stop. Violation of any of the above conditions will entail automatic cancellation of the bail. The applications are accordingly disposed of. The petitions are accordingly disposed of. Then before that, ite para para 22A. Para 22A. As can be seen from the records and the petition from the record, the petitioner's default bail application which had been submitted under section 187 of the BNSS, read with section 36 capital A bracket 4 of the NDPS Act, 95, had been filed on 21/3/2025, that is after the expiry of 180 days and prior to filing of the charge sheet, which had been done on 11/4/2025. The petitioner's application for default bail was registered as bail application number 90 of 2025 in the special court NDPS Act, ISOL. The same was, however, dismissed by an order dated 21/3/2025 on the ground that the time period, on the ground that the extension for completing the investigation had been extended. No, on the ground that the extension of the investigation period had been allowed. No, on the ground that extension of the investigation period had been allowed on 13/1/2025. This court thus finds that as the impugned order extending the investigation period by order dated 13/1/25 passed in NCB crime number 5 of 23 was illegal and not sustainable. The rejection of the default bail application by the petitioner void bail application number 90 of 2025 could not have been dismissed. The petitioner should have been released on default bail, comma, but for the illegal order dated 13/1/2025. Illegal impugned order dated 13/1/2025. Oh, I know it. Okay. So you are also done. Granted. Huh?
My
So
lord.
these two petitions are disposed of.
My,
Item 3 and 4. No? No, 4 has been finished. Now with your case, madam.
my lord, please, I'm sorry for interruption, my lord. So may I have only one request because regarding the she shall not leave the jurisdiction of the special court because I am a permanent resident of Champhai, which is beyond the
Okay,
jurisdiction
okay.
of
He shall
this
not
court.
leave. He shall not leave the state of Mizoram
My lord.
without the permission of the special court as well. Huh? Mizoram. Don't go to Burma.
No, my lord. She is a permanent resident, my lord.
Okay.
Highly obliged.
Okay, so your job has become easier, madam. At least I can your petition for I think because it will go same. Default bail not we're not going to grant default bail because there is no bail application here.
My lord.
We can only grant you
Question.
huh?
Question of the order.
Quashing of the order. Is there any default bail applied earlier by you?
My lord,
You did not apply.
I did not handle the case in the district court. My
If
lord,
you-
we had
No, madam, that is not the. I am asking a simple question. Did you apply for default bail
in the district court.
in the special court?
My lord, the default bail 180 days lapsed on 19 January 2025. However, the extension was allowed
Even prior
on
to that.
14th.
I know.
Or 13 or 14.
Correct. But then, did you apply? I'm asking. Did you apply for bail? Have you
No,
applied for default bail?
My
No.
lord, yes, I have applied here.
Where is that? No,
Here is
here,
my
not here, not here. Here, how can you apply
My
here?
lord, why would I apply? Because I was informed that there was an extension already. So that's why I came to the higher court for the challenge to quash this order and invoke section 187 of the BNSS. And in my prayer also, I have specifically mentioned to be released on default bail. And this was filed on way before the charge sheet was filed. It was filed on 6th of March.
This is what? This is what? This is here. This is here. This is 3 and 4. This you can take. You can take all this. Then item, your case, let us see. This is a criminal petition. Affidavit in opposition. Madam, for a
My lord, at page 6 of my application, of my petition.
6 March. She has applied before the. She has applied. When was the? Just give me the first file. When was the 11th? 11 May. 11
April.
11 May. 11.
April.
Huh?
April.
11 April. The others have not asked. Correct. The other
The
persons.
others, I'm not, I don't know, my lord, the other,
don't think
except
so.
Kola Rampari.
So yes, her petition for default bail is of 6th March, and the charge sheet has been filed on April 11th April.
This is, Your Lordship, a criminal petition, not a bail petition, Your Lordship. This is for quashing, my Lord. So can we
My lord, a specific prayer is made at page 6.
incorporate everything, criminal petition and bail petition all together in one petition?
What is the harm? Show me the Guwahati High Court rules. Where does it say that it has to be separate?
Bail petition, my Lord, is a criminal. Actually, now, my Lord, here in
Have you
there is no.
have you taken that plea?
Yes, my lord, at page 6, if
No. I'm asking the Mr. Zoram Chana. Have you said that you cannot ask for bail in this petition in the affidavit? In your affidavit, what have you said?
No, my lord, it's a question of law, my lord.
So no. It's a question of law. How is it a question of law? It's a question of procedure. You might
Actually,
say.
yes.
It's not a question of law.
I-
It's a question of procedure. It's not a question of law. Yes. So,
Can we have this some other date, my lord?
yes, so what do we do? Do we say tell the authorities to take a decision on the petition's representation? What?
Yes, my lord. I
Y'all
had
can
received-
y'all can decide whether he is entitled to any compensation, whether the village council is valid on pass is valid or not. Y'all can decide. But
My lord, the land belongs to the environment and forest, so clearance have already been obtained.
it doesn't belong to him.
Yes, my lord. As far as the oral instruction that I receive.
Then let him file an affidavit. Okay. Right, Miss Lalngai Sakifana, council appearing for the respondent number.
3, my lord.
He submits that the land on which the petitioner had planted his crops
Yes, my lord.
belongs to the environmental and forest department. Correct?
Yes, my lord.
And as such, there is no question of paying compensation for damages. Full stop. The issue here is with regard to whether the petitioner can be paid damages for crops and trees planted by him on land covered by a village council pass issued in the year 2016, keeping in view the provisions of the Land and Revenue Act 2013. List the matter after 4 weeks to enable the respondents to file their affidavits.
Right.
Item 6.
Or, madam, if we can still tell them to decide the petition. Otherwise, you want to file affidavit or what?
No, my lord, it's just this. This is an order dated 21 December 2023,
Which says,
which says that the NHIDCL has made necessary payments as per the principal approval of the project for the forest clearance and everything.
that's a different issue.
My lord, pending read petition also he can dispose of. There is no bar. So the petition can become in purpose. There is no bar.
Yes, my lord.
Yes,
My lord,
right.
Their only
right.
prayer is representation.
Right. Heard Mr. Zoram Chana, Land Counsel for the petitioners. Also heard Ms. Caroline Lung Oipui, K. Lung Oipui, Land Counsel appearing for the respondents number 1 and 2. And Mrs. Lalngai Sakifana, Land Counsel for the respondent number 3. Give me that petition. The petitioner's case is that this one, para 2, para 3, para 4. Para 4, okay, of the last order. Para 2, 3, 4. Then, para 5, you say, Mrs. Caroline K. Lung Oipui, learned government advocate appearing for the respondents number 1 and 2, and Ms. Lalngai Sakifana, learned counsel appearing for the respondent number 3, submit that they do not have any objection if the petitioner's prayer for consideration for examining the petitioner's representation dated 8/11/2024. There's only one petitioner. 8/11/2024. Is allowed. Accordingly, in view of the consent of the parties, the respondent number 3 is directed to examine the case of the petitioner and take a decision as to whether with regard to whether the petitioner is entitled to any damages in terms of his representation. The respondent is the concerned. The respondents are also given the liberty to take a decision as to whether the petitioner's village council pass is a valid pass in terms of the applicable land laws of the state. That's all. The entire the petitioner's representation should be decided and decision taken by the respondent number 3 within a period of
What? 2 months.
2 months from the date of receipt of a certified copy of this order. The writ petition is accordingly disposed of.
I'm obliged, my lord.
Obliged.
Item 6.
May I please, your lords?
Yes.
My lord, with all respect, my lord. NDPS, my lord.
Huh? Yes.
NDPS, my
Yes,
lord.
yes.
My lord, the post-arrest bail application, my lord. Primarily on the ground, my lord, as regards violation of Constitutional Article 22(1) and Section 47-48 of the BNSS, my lord. Pursuant to the authorities of my lord, Probir Purukayastha and Vihan, my lord. Here, my lord, with all respect and full hands, my lord, we have annexed the arrest memos. Those occur at page 23, 25, and 27, as because there are 3 accused persons, my lord. And the arrest memos, my lord, with all respect, my lord, in my understanding as a student of law, my lord, they contain only, my lord, with all respect, my lord, the reasons of arrest, not the grounds of arrest, my lord. That is one point. That is violation of, my lord, with all respect, my lord.
Just tell me one thing. Has the charge sheet been filed?
Yes, yes, my lord.
Charge sheet filed already.
Charge sheet file, my lord.
What is the status of the trial?
That we do not know, my lord.
Yes, what is the status? Charge framed?
Lordship, as far as my knowledge is concerned, Lordship, it's in the prosecution witness charges. I'm not sure whether it is frame or not, Lordship.
Okay, then. So when was so the charge sheet filed?
It was filed on,
Then you had asked for bail before the trial court.
No, my
After
lord.
charge sheet filed,
Charge sheet filed during pendency of this petition. During pendency of this application, charge sheet was filed.
then you go and ask. You go to the trial court.
My lord, can I just play before your lordships, my lord? This has been made clear in Probir Purukayastha, my lord. If violations are there as regards 27, 47 and 48, my lord.
Which case? Which case?
Probir Purukayastha, my lord.
Yes, what is the citation? I've got no idea.
Oh, I'm sorry, my lord. 2024 8 SCC, page
2024 8 SCC,
page 254, my lord.
254.
May I just read one paragraph?
Para.
Exactly, my lord. Even in charge sheeted cases, 19, 21, and 48. If your lordship permits me, I can.
No, I've got it here.
Yeah. Para 19. Should I read, or my lord?
Yes.
My lord, with all respect, my lord. My lord, can I come to my lord, the sections of law first, my lord? I'll take a minute, my lord. With all respect, people also permits me, my lord.
What?
My lord, the grounds of arrest, my lord. Earlier in the CRPC, my lord, it was 50. And my lord, relatives are to be informed. That is 51 capital A, my lord. Now, my lord, in BNSS, my lord, it is section 47 and 48. And it emanates from article 22(1), my lord. When a man is arrested, my lord, he is to be provided forthwith with the grounds of arrest, my lord. That has first been decided by this authority, Probir Purukayastha, my lord, in 2024. Now I am reading, my lord, with all respect and full adherence, my lord, para 19, my lord. May I, my lord?
Yes.
My lord, may I read, my lord? Para 19, my lord. Resultantly, there is no doubt in the mind of the court that any person arrested for allegations of commission of offences under the provisions of UAP, they said that was a heinous act, my lord, in which bail was granted in a charge sheeted case because of violation of section 47, my lord. UAPA, Unlawful Activities Prevention Act, and their embargoes are there, my lord, regarding grant of bail, my lord. Restrictions under section 37. Here, my lord, the same, my lord, same situation, or for that matter, any other offences, has a fundamental and statutory right to be informed about the grounds. May I just turn the page, my lord? Grounds of arrest in writing, my lord. That has been provided in writing, my lord.
Yes,
and a copy of.
Okay, then.
My lord.
What else?
Then, my lord, para 21. The
Yes.
right to be, may I, my lord?
Yes.
The right to be informed about the grounds of arrest flows from Article 22(1) of the Constitution of India. And any infringement of this fundamental right would vitiate the process of arrest and remand. Mere fact that a charge sheet has been filed in the matter would not validate the illegality and unconstitutionality committed at the time of arresting the accused, and the grant of initial police custody, police custody remand to the accused. Thereafter, my lord, para 48, my lord.
Yes.
Para 48, my lord. With all respect, my lord. It may be reiterated at the cost of repetition that there is a significant difference in the phrase reasons for arrest and grounds of arrest. The reasons for arrest, as indicated in the arrest memo, are purely formal parameters. That is, to prevent the accused person from
Yes.
committing any further offense. Papa, it goes on and on, my lord. The reasons for arrest, last lines are very important, my lord. My lord, with all respect, by leaving aside 2-3 lines, my threat or promise, these reasons should commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest is very important, my lord, would be required to contain all such details in hand of the investigating officer which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all basic facts on which he was being arrested, so as to provide him an opportunity of defending himself against the custodial remand and to seek bail. Thus, this line is the paramount, my lord, ratio, that the grounds of arrest would invariably be personal to the accused and cannot be equated with the reasons of arrest, which are generally in nature, my lord. Here, my lord, 3 accused persons arrested, copy-paste, my lord, so absolutely copy-paste, my lord. With all respect, my lord, so grounds of arrest are not personal. This is violation of, my lord, 47. And 48, nothing has been submitted, my lord. And that is not in this authority, my lord. May I come to the subsequent authority, Dhihan, my lord. 2025 SCC online, SC 269, my lord.
Yes.
This authority clarifies, my lord, with all respect and forbearance, my lord, that, my lord, even in a charge sheeted case, at a later stage after charge sheet being filed, if it comes to the notice of the honorable court or it is brought to the notice of the honorable court, the section 47 and 48, they have been violated, then the accused deserves to be released on bail, my lord. Now, my lord, with all respect, my lord, the subsequent authority, it clarifies everything, my lord, that in a case of NDPS also, these violations are paramount, my lord.
Where is
that
that?
occurs, my lord.
Where is that? Which para?
My lord, conclusion 21, my lord, para 21C, my lord.
Yes.
First, I'm sorry, my lord, 21, my lord, with all respect, my lord, F, lordship has found, my lord,
Yes.
where a violation of Article 21 to 22(1) is established, it is the duty of the court to forthwith order the release of the accused. That will be a ground to grant bail, even if statutory restrictions on the grant of bail exist. So this would be applicable to NDPS Act because statutory bar is there, that embargo in section 37, my lord. With all respect, my lord. Thereafter, my lord, with all respect, my lord.
How is this applicable?
My lord.
How is this applicable?
No, my lord. Grounds of arrest not provided, my lord. May I come to the annexes which we have annexed, my lord?
Yes.
My lord, there are 2 sections of law, my lord. I'll be very, it will be paramount, my lord. First is 47. In 47, what the investigating agency has done has equated the reasons of arrest that I read out, my lord, para 48 of, my lord, Provir Purukayasta, my lord. There it has been distinguished that grounds of arrest and reasons of arrest are different, my lord. That, my lord, that if I may place it before your lordship's notice, my lord, Lordship may kindly have a look at page 23
Yes.
of the petition, my lord.
Yes.
There, my lord. Then we goes on at 27, my lord.
Yes.
I am reading it out, my lord. Copy 23, my lord.
Yes.
This is as regards accused number 1.
Yes.
Brief facts of the case. List of evidence. Goes, my lord. Regarding the second accused, same copy paste, my lord.
Yes.
25, copy paste. Thereafter, 27, copy paste. So these are all reasons of arrest, not grounds of arrest, my lord. Because grounds of arrest are to be personal, as has been held in Probir Puruka stand para 48. On the top of it, my lord, this is a clear violation. If I read the second authority, which is, my lord, Vihan, subsequent to Probir Puruka 2025 SCC online, page 2669. That I have, with all respect, my lord, placed before your lordships. There it occurs, second last page, judgment authored by Honorable Justice, my lord, N. Koteshwar Singh, Honorable Justice, my lord. There occurs para 2, leaving aside 5, 6 slide. Sorry, my lord. Second last page, my lord.
Yes.
Vihan, my lord. Lordship has found, my lord.
Yes.
Para 2, my lord. With all respect, my lord.
Yes.
Leaving aside, I am counting the lines, my lord. 1, 2, 3, 4, 5, 6, 7, 8, 9. Leaving aside 10 lines from the top, my lord. 11th line.
Yes.
From in between, my lord. From the middle, my lord. It may also be noted that the aforesaid provision of requirement for communicating the grounds of arrest to be purposeful is also required to be communicated to the friends, relatives, or such other persons of the accused as may be disclosed or nominated by the arrested person for the purpose of giving such information as provided under section 50A of the CRPC. That was the earlier code, my lord. Now it is 48, my lord. With all respect, my lord. As may be noted, this is in addition to the requirements as provided under section 51(1) of CRPC. That 47, next paragraph, my lord. The purpose of inserting section 50A of the CRPC, making it obligatory on the person making arrest to inform about the arrest to the friends, relatives, or persons nominated by the arrested person, is to ensure that they would able to take immediate and prompt action to secure the release of the arrested person as permissible under the law. The arrested person, because of his detention, may not have immediate and easy access to the legal process for securing his release. It goes on and on, my lord. And thereafter, my lord, after leaving aside 3-4 lines, my lord, and in addition to his relationships as mentioned above, is not merely a formality, meaning thereby, if 47 is complied with, 48 is also a must. Otherwise, it is an exercise in futility of the investigating agency. But to enable the detained person to know the reasons for his arrest, but also to provide the necessary opportunity to him through his relatives, friends, or nominated person to secure his release at the earliest possible opportunity. For actualizing the fundamental right to liberty and life as guaranteed under Article 21 of the Constitution. Hence, the requirement of communicating the grounds of arrest in writing is only to the arrested person, is not only to the arrested person, meaning thereby not only section 47 is to be complied with, but 48 has also to be complied with of the BNSS, my lord. Hence, the requirement of communicating the grounds of arrest in writing is not only to the arrested person, but also to the friends, relatives, or such other persons as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22(1) of the Constitution meaningful and effective, failing which such arrest may be rendered illegal. Here, my lord, with all, and my lord, on the basis of these two authorities, my lord. My lord, I do this. My lord, with all respect, my lord, one Guwahati High Court.
Yes.
May I, my lord?
Yes.
May I, my lord?
Yes.
My lord, then about
So
on the lines of
these drugs were found in which vehicle?
second vehicle, my lord.
In the Tata Zanon.
Exactly, my lord.
And you were sitting where? In the first vehicle?
First vehicle, my lord. Scorpio. Another application, my lord, by this Honorable Guwahati High Court, my lord, on the basis of subsequent to Prabir Purukayast and Bihan, my lord, followed the authorities, Article
Okay,
141, my lord.
I think, yes, then what else? Any other thing besides that? There's no point going on and
My lord,
on.
can I place a coordinate bench order, my lord?
Huh?
Ijol bench order, my lord.
Yes, you can put anything.
May I, my lord?
Yes.
Yes, my lord, bail application number 2 of 25. That authority I have placed before your lordships, my lord. Bogesh Sardar, dated 5/3/25.
Yes.
There, my lord, I am reading. Para 10. Leaving aside some lines from the top, my lord. Next page, 6th line, my lord. It is also held. Lordship has found. my
Yes,
lord.
yes.
It is also held that the aforesaid provisions of requirement for communicating the grounds of arrest to be purposeful is also required to be communicated to the friends, relatives, or such other person or accused as may be disclosed or nominated by the accused person for the purpose of giving such information as provided under section 50A of the Code of Criminal Procedure. Now it will be section 48, my lord, in BNSS. And this is in addition,
I think you
My
should
lord.
go to the trial court.
my lord.
I think you should go to the trial court. Since
Well,
since the charge sheet has been submitted.
Lordship.
My lord, my lord, can I just academic?
No,
my
no,
lord?
no more time. How much time will you take?
I'll take a single minute, my lord. If you
Okay,
lordship
yes.
permits
What
me,
is
my
the, I
lord.
mean, yes.
Well, there, my lord, in Prabir Purukayast's case, it has been made clear, my lord. Even if charge sheet, apex court granted bail, my lord. So it would be
That is discretionary. Where does it say that?
yes, yes,
Page-
my lord. Can I just read it, my lord? Para 21, my lord. Also in Bihan, my lord, reiterated, my lord. Para 21. May I just read it, my lord? The right to be informed, lordship has found, my lord. The right to be informed about the grounds of arrest flows from Article 22
No, you
of
see,
the
it does. I am not saying would validate the illegality. I am just saying that you go to the trial court.
My lord,
that's all.
my lord, we will have to move there again, my lord.
Yes,
From
you
here,
move
my
it.
lord.
You move it. I think you that's the correct way.
It is clear non-compliance, my lord.
You
Clear
go-
non-compliance.
you-
My lord,
you-
can I
you take- you
read
take it
another
up
more
before
line, my
that.
lord? No, your lordship is correct, my lord. Can I read just one more line, my lord? My lord, can I add one lead, my lord? If it is found that these are, my lord, violated, then 1 minute, of course, just academic, my lord. May I just place it, my lord? May I just place it, my lord? Para 14 of Bihan, my lord. Para 14. Just, my lord, I'm pursuing, my lord, with all respect, my lord. There is another one also, my lord. Para 14 of Jihan, my lord, second authority. Once the arrest, last time, my lord.
Yes.
Para 14, my lord.
Yes.
Once the arrest is held to be vitiated, because vitiated, my lord. Not even provided for 48, my lord. Total violation. The person arrested cannot remain
Let
in
the trial
custody
court decide now.
even for a second.
Yes. Yes,
And my
Mr.
lord-
Johnny. Yes.
Yes.
My lord, another authority.
No, no,
my lord,
yes.
Yes, a huge quantity of the heroin was recovered from the vehicle, and all of them are having involvement. This as per the voluntary statement and the investigation done by the department in lordship. And this is the 2,696 grams of the heroin was recovered. And your lordship, there was a condition under the NDPS Act, section 37 of the NDPS Act, your lordship. There's a twin condition which needs to be satisfied by the petitioners, your lordship. And the twin condition is that, your lordship, where the public prosecutor opposes the application, the cause is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and he is not likely to commit any offense while on bail, your lordship. The two conditions is not satisfied from the plain reading of the bail application, because this is very premature, your lordship. So, and your lordship, there are so many Supreme Court ruling. One is, your lordship, 2007 7 SCC, 2007 7 SCC, 798, page number 798. Para number 5, lordship. Para number 567. Married, lordship. Para numbers 5 is at page 800.
Yes, yes.
Section 37 of the Act reads as follows. Section 37, offenses to be cognizable and non-bailable, notwithstanding anything contained in the Code of Criminal Procedure, such and such. A. Every offense punishable under this Act shall be cognizable. B. No person accused of an offense punishable for a term of imprisonment 5 years, such and such, Lordship. And number 1, the public prosecutor has been given opportunity to oppose the application for such release. Number 2, where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on bail. To the limitation, this is not relevant, Your Lordship. Para number 6, as the provision itself provides that no person shall be granted bail unless the two conditions are satisfied. There are the satisfaction of the court that there are reasonable grounds for believing that the accused is not guilty and that he is not likely to commit any offense while on bail, but the conditions have to be satisfied. If either of these two conditions is not satisfied, the bar operates and the accused cannot be released on bail. Also,
Yeah, just tell me, there were two vehicles, correct?
the two vehicle lawsuit.
One was a Scorpio and one was a Tata Xenon.
That Xenon lawsuit.
These petitioners were sitting where?
Sitting on the second one, Your Lordship.
In the second one.
And lawsuit, yes.
And the goods were and the contraband was found in the first vehicle.
The first vehicle. And Your Lordship, from the second vehicle, they are the person who had opened the special cavity, which is the first vehicle.
Okay,
they are the one who
the persons in the second vehicle opened the
Not
special
all, my
cavity.
lord.
Your Lordship. Yeah, this the investigation reveals everything, Your Lordship. So there is a prima facie case, Your Lordship.
Where is that reflected?
Lordship, that is in the charge sheet, Your Lordship.
Page 21, my lord, of the application, my lord. One accused, PB to knowledge, not the rest two. Out of 3 accused, one is PB to knowledge. He opened it. Petitioner number 2, my lord. Page 21. Second last paragraph, my lord.
Yes, anything else?
Hey,
Lordship,
my lord, can I?
Just a
Sorry, my
minute,
lord.
let me hear him. Yes.
Lordship, because their involvement, all of them are involved in this case. So this honorable court maybe rejected this application, and they have a liberty to approach the.
Have they gone before to the?
No, no, Lordship.
So they've come directly
Yes,
here.
They come directly here.
You have never gone to the trial court.
Before we do not know, my lord. Can I just answer
You have never
it,
gone
my-
to the trial court.
My lord, the information I don't
You
have,
have
my
not
lord.
given.
Can I just, whatever he has said, my lord, can I just place two authorities, my lord, negating him, my lord? Because, my lord, the twin embargoes are pointless. This is 2007. In 2025, it is clarified in Bihan F, my lord. Despite the embargoes will not be applicable. Is there is a violation of constitutional and statutory rights under Article 22(1) and non-serving
I
of
know.
notice.
What you are trying to say is that the initial arrest was vitiated.
Exactly. My lord,
So
second, can I just say-
the second issue does not come into consideration.
Yeah,
That's what
exactly.
you're
This
trying to say.
merit omitted.
We'll have
Merit
to
is
see. We'll
omitted.
have to see. This is
One
the-
judgment, my lord. One more judgment, my lord. Just I'll place it 2 lines, my lord. Subhash Sandra, my lord.
Citation.
2025.
Huh?
2025. SCC online.
SCC online
ST 240.
240. Para.
There I read.
Huh?
May I read? Para 8, my lord.
Right. Yes.
Once a court, while dealing with a bail application, this is a bail application, my lord, with all respect, finds that the fundamental rights of the accused under Article 21 and 22.
I am
This
not
is
going to make any finding. Sorry. I'm not going, since you have not approached the trial court, you should go first then.
Yeah, my lord, can I just read it, my lord? I just need this paragraph, my lord. Should I?
I understand. Once the court finds that Article 22(1) has been violated,
My
then
lord.
it should, then there's no question of denying bail. Denying bail. But I am not going into the question of whether there has been a violation of 22(1) or not. Let it be tried by the
My lord,
trial court.
Lordship, kindly note it in the order that the court below will look into it, my lord. Whether by
Once you approach,
my lord, that my prayer may be recorded, my lord. Otherwise, it will be conflict, my lord.
yes. I'll record everything.
Yes, my lord. Yes.
Heard. Mr. B.K. Mahajan, learned counsel for the petitioners, and Mr. Johnny L. Tochong, learned special PP
Lordship, yes.
for the respondents, for the
Respondent.
respondent state, for the respondent state.
Yes.
Union of India, Lordship.
First up, this is a bail application filed by the three petitioners who had been arrested on 12/8/24 in connection with the seizure of
2,696 grams of heroin.
2,696
grams of heroin.
grams of heroin. That's all. Anything else? Only heroin. Where is the arrest seizure memo? Let us see.
On page 22, it is 3,696.
Page 22, my lord.
Page 22. Grams.
In connection with the seizure of 3696 grams bracket net weight. 3696 of heroin valued at rupees 25 crores 87 lakhs 20,000. First stop. The heroin had been recovered from a Tata Xenon bearing registration number MZ01F-1845 coming from Churachandpur, Manipur and heading towards Silchar, Assam. The vehicle was being followed by a black Mahindra Scorpio bearing registration number AS01BJ-8894. Page 20. The petitioners herein were sitting in the Mahindra Scorpio, black Mahindra Scorpio, while two co-accused, namely Shri S. Khaigomang Mate and H.L. Shongongam Mate were in the Tata Xenon. And moving to page 14 now. 4 and 5, serial number 4 and 5. The heroin was recovered from a secret compartment slash cavity of the Tata Xenon, which was opened by the petitioner number 2, who was sitting in the black Mahindra Scorpio. The heroin was packed in 308 soap boxes, which were concealed inside the specially designed cavity in the Tata Xenon. Next para. The petitioner's counsel submits that in terms of the decision of the Supreme Court in the case of Prabir Purkayasta versus State NCT of Delhi 2024 8 SCC 254. And in the case of Vihan Kumar versus State of Haryana and another reported in 2025 SCC online SC 269. A person arrested on the allegation of having committed an offence has a fundamental and statutory right to be informed about the grounds of his arrest in writing, and a copy of such written grounds of arrest have to be furnished to the arrested person as a matter of course and without exception at the earliest. He submits that when there has been a violation of the above, which is reflected in Article 22 (1) of the Constitution, it is the duty of the court to forthwith order the release of the accused. He also submits that in terms of the above judgments, the mere fact that a charge sheet has been filed in the matter would not validate the illegality and unconstitutionality committed by the enforcement agency at the time of arresting the accused persons, and the grant of initial police custody. Full stop.
Should I, my lord, 48 also, my lord, that may be added, my lord. Section.
He submits that there is a significant difference in the phrase reasons for arrest and grounds of arrest. and unless the grounds of arrest are informed to the arrested accused, the court will have to grant bail to the accused, as the same would be in violation of Article 21 and 22 of the Constitution. Pusta. What is this? 2025. That's all.
My lord, section, my lord, relatives are to be informed, my lord. Dhihan paragraph, my lord.
NDPS
My lord, the
He also
last page, my
submits that the relatives of the accused persons
lord.
were to
Section
be,
48
were to,
Lordship Act,
were
my
to
lord,
be
that will be
informed
enough.
of the arrest of the
Conditions by section 48, my lord,
petitioners
BNSS.
in terms of section 48
My lord, BNSS, my lord.
of the BNSS.
My lord, my lord.
Full stop. However, the same was not done. Full stop. Next, on the other hand, no, he accordingly submits that as the grounds of arrest has not been stated by the, has not been informed to the petitioners at the time of their arrest, the petitioner should be released on bail. Full stop. Next para. Mr. Johnny L. Tocham, the learned special PP, submits that the grounds of arrest have been informed to the petitioners and that bail cannot be granted unless the twin conditions provided under section 37
Lordship, yes.
of the NDPS Act is complied with, is fulfilled.
Lordship, yes.
In this respect, he has relied upon the judgment of the Supreme Court in the case of Dash versus Dash, reported in 2007, 7 SCC 798. That's all.
Lordship, besides that, all of them had admitted that they are transporting the
Full stop. He
substance
also
of-
submits that the petitioners were escorting the Tata Xenon
Yes.
and they had all
NDPS.
admitted. You said admitted or what?
Admitted, Lordship.
And
Admitted in
admitted.
their, yes, in voluntary statement. They have
Had
admitted.
admitted in their voluntary statement made to whom?
Made to the
Police officers, my lord.
DRI officers.
Made to the DRI officers. Made to the Directorate of Revenue Intelligence, Directorate of
yes.
Revenue Intelligence, bracket DRI officers, that they had what?
Lordship, they are transported
That
those.
they were transporting.
Yes, in order to earn some money, Lordship.
They were transporting the contraband to earn some money.
Lordship, yes.
He also submits that charge sheet has been filed and the status of the criminal proceedings is in the evidence stage.
Evidence stage, Lordship. Yes.
Evidence stage. Full stop. He also submits that the petitioners have never approached the trial court.
That will be not.
Is it correct?
Lordship, yes.
Have not approached the trial court with the bail application till date.
I don't know.
And as such, they should be directed to approach the trial court. Full stop. What's happening?
My lord.
What's happening to the screen? Can you see me?
Yes, my lord.
I
With all
can't see
respect,
you.
my lord, I
There's
can see
something with the screen.
I can see your lordships.
Can you see
Okay.
that screen? It's like I am seeing you like this. Anyway,
My lord, can a line be added, my lord?
what?
My
No
lord,
more, no
there's-
more lines.
there's-
No more lines. No more
no.
lines. You
F,
do
my
whatever
lord.
you do that. Right.
My
I have
lord,
heard.
if
I have
F is
heard the
added, my
learned counsels for the parties.
F, my lord.
I have heard the learned counsels for the parties. On considering the fact that the charge sheet has been submitted by the state respondents and the cases at the trial stage, comma,
Lordship, Union of
The-
India, not state
Huh?
respondent. Union of India.
by the state, Union of India is also state,
Yes, yes, state.
Will state the petitioners should approach the learned trial court first. Full stop. The reason being that the petitioners have never approached the trial court for bail prior to filing the present bail application. Full stop. Thus, without deciding the issues raised by the petitioners in this
Right.
bail application, this bail application is dismissed, with liberty is rejected, with liberty being given to the petitioners. No, not dismissed.
Dispose of, my lord, dispose of.
Dismissed. The petitioners are at liberty to approach the special trial court, the trial court, with a fresh bail application, wherein they can agitate
My lord.
wherein they can pray for, wherein they can apply for
Constitutional
bail.
and statutory rights, my lord.
As per, rejected. Has been rejected. That's all. That's all.
My lord, rejected may be, my lord, dispose of, otherwise it will be a bar, my lord.
Okay, is rejected. Is disposed of with liberty being given to the
My lord.
is being disposed of.
With
As
liberty to-
being disposed of without deciding the case on merits,
My lord.
as the petitioners have not approached the learned trial court before approaching this court.
My lord.
The bail application is accordingly
Dispose of.
disposed of. Okay.
Highly obliged, my lord. Highly obliged. Highly obliged.
Item 7.
If I may please, Your Lordship, this is also bail application.
Mr. Johnny, you just come and meet me, okay? Item? Yes, what is to be done here, madam?
My lord, this is also bail application.
Oh,
My lord, just like
No
the
time.
previous one,
huh?
just like the previous one, our main grounds is violation of Article 21 and 22 and violation of Section 42 as well. And then no recovery was made from this particular applicant, and he was arrested after 1 year and 4 months from the seizure of the contraband drugs. And we had also gone to the trial court, and it was rejected on the grounds that, my lord, it's at page 19. I'll make it fast.
Can also take it up tomorrow, my lord.
Yeah, I think I've got a lot of work. I've got so much. Your orders also have not even started.
Yes, my lord.
Otherwise, I'll have to pass your orders after I come back.
My lord.
My lord, tomorrow I have another hearing as well, DP matter.
You
Six
might-
item. So if it can be taken up
I
today.
have got, I think, a number of CVs now with this week only. So many, every day we are disposing of one whole, a few cases, or criminal cases
Tomorrow.
take time, is it? One judgment takes around, I don't know, 30 to 40 paragraphs.
My lord, we have a good case. I'll make it fast. I'll go to the point.
Tell me what, yes?
My lord, we had applied for bail in the trial court, and it was rejected. It's at page 22.
It's so thick. I don't think you'll finish early, madam. Let me see tomorrow if you have
Tomorrow,
got time. Because I've got a lot of work. I've got a lot of pending matters.
Yes, ma'am.
Let me finish those. I've got to give a dictation. Today's judgment, today's CAV also, I've not even started dictation.
Yes, ma'am.
Okay. List the matter tomorrow. Let's see if we have time. If we have time, it's okay. If we don't have time, then we'll try, because it's very difficult. I've got to pass your order also, the other one. I have not even started on that.